So you want to record a deed at the Register of Deeds, and you're not exactly sure what the formal requirements are for the deed as you are creating it. Hi, I'm Darren Findling of QuietTitle.com, and we're going to spend some time discussing the formal requirements of the recording of a deed in Michigan and what's required specifically on that deed. Now again, this video is going to give you the basics, and in no way should it be an excuse to avoid hiring a lawyer or a competent professional to assist you in doing it. So let's start off. The deed itself has a grantor. That's the person that's conveying the property to a grantee or grantees. That person has to sign it. The grantor or grantors that are conveying out the property must sign it in what we call wet ink. That is ink that is done with a pen. So digital signatures are typically not permissible, or copies of the documents themselves are not recordable for purposes of the Register of Deeds. Important to note is that the grantee, the party that is receiving the deed, is not a requirement under MCL 565.201, which is Michigan statute, for purposes of receiving or accepting delivery of that deed. There's no requirement of a grantee to sign the deed itself. The grantor's name must be legibly identified on the deed in either typewritten or printed in legible ink, so that a person that's viewing the document could read it. That's what they mean by legible. And of course, every person that is conveying must actually sign the document, and it must be notarized. Now, the notary itself is a requirement, and there's a separate notary statute, but the notary's name and signature block, we call it, which includes the notary's expiration and county upon which they're commissioned, is required on that deed, although the seal, the one that has the embossing, is not a formal requirement under Michigan's recording provision for purposes of the deed. Nor are witnesses. There used to be a witnessing requirement that's gone, and the notarization is the requirement, although a witness or witnesses on the deed in no way affect or impact the deed's ability to be recorded. So the deeds being witnessed are just extra. It doesn't in any way harm its ability to be recorded with the Register of Deeds. And the other thing is that the paper has to be no larger than 8.5 by 14, which is what we would call legal size paper in the old days. Most deeds now are going on 8.5 by 11. But remember, in the old days, there used to be very large, almost poster-sized deeds when people would convey property from one person to another. Those deeds may satisfy the formal requirement of conveying to another person, but it wouldn't satisfy the requirement of recording. So if you want that deed to be able to be recorded at the Register of Deeds, it is required that the deed itself be on a piece of paper that is no larger than 8.5 by 14. And there are some other requirements about what can occur within that piece of paper, and I'll refer you to the statute MCL 565.201. You could do a simple Google search to be able to view the statute, or you can look at a link on our particular website. Here's an interesting provision of the statute. The Register of Deeds is simply a depository of deeds, and they are specifically prohibited from rejecting the recording of a document that otherwise conforms with Michigan's recording statute. So this comes into play quite often when there is a deed that clearly is being inappropriately recorded or fraudulently being recorded. The Register of Deeds is the depository, the place upon which the deeds are going to be deposited. The court system is the place where decisions regarding the legality or the appropriateness of those recorded documents get adjudicated. So for example, if I convey a deed to a hotel, the Remsen, whatever it may be, or the Ambassador Bridge, and I don't own it, the Register of Deeds still is required to record it as long as it complies with the recording requirements under the statute. But they're not going to identify the legitimacy or credibility of that deed. That's for the courts to do, and that's for lawyers like me who do quiet title work, can get involved and address the correctness of the particular recording of the deed. So I'm giving you just some basics on the execution of a deed, whether it be a quitclaim deed or a warranty deed or other recording documents for purposes of recording with the Register of Deeds. If you've got further questions, reach out to us. We'll help you. We'll talk to you. 877 Your Firm. That's 877 YOURFIRM. Lots of really valuable information on our website, quiettitle.com. We're always happy to talk with people, meet with people. Give us a ring. Look us up online. Good talking to you.